Mr. Chairman, members of the committee, House Bill 1248 is before you to bring consistency into Virginia's law as far as how we treat juveniles as being under our judicial system as far as criminal intent. There are several places where a child under age 11 is not held in detention, et cetera, and this makes it uniform throughout our law of treating children under age 11 in the same way. This is a recommendation that comes from a number of sources. I know we have people online and people here to testify, so I will defer to their articulate expression of the need for this bill. But again, I do bring it before you to bring that consistency. You do have a substitute before you, and the substitute in particular brings into it a concept that VACA, upon their review, were concerned about. But again, we will discuss that perhaps after the testimony, or I can discuss it at this time.
All right. Well, it's up to you. Would you prefer to hear the testimony first?
Yes, let's hear the testimony first. It'll bring the context better in focus.
All right. Anyone in the audience first?
Good evening, Mr. Chairman and members of the committee. James Dold on behalf of Human Rights for Kids, here to testify in support of House Bill 1248. We first want to start off by thanking Delegate Watts for her leadership in introducing this bill. Human Rights for Kids, we're a 501c3 nonprofit organization dedicated to the promotion and protection of the human rights of children. Our board of directors is somewhat unique in that we have 11 state legislators, current and former, from around the country. We have 6 Republicans, 5 Democrats, from states as conservative as Arkansas and Utah to as liberal as Vermont and Hawaii, who have all come together to work to advance these basic human rights protections for children in our criminal legal system. We are here testifying in support of this legislation because establishing a minimum age by which children are incapable or deemed incapable of transgressing the criminal law is in fact a human rights issue. Over the years, juvenile brain and behavioral development science has demonstrated that children aren't simply miniature adults. They are fundamentally different than adults and need to be treated differently. Specifically, the prefrontal cortex isn't fully developed in children, which means that they actually rely on a more primitive part of their brain known as the amygdala when making decisions and processing information. This is especially true for very young children, and this bill specifically targets children who are in 4th grade and younger. So we're talking about kindergartners, 1st graders, 2nd graders, 3rd graders, children 10 years of age and younger. We place all sorts of restrictions on children, and this bill is in keeping with that and recognizing that they are different. Specifically, children under the age of 11 do not have, in our estimation, the ability to form mens rea, that is criminal intent. They should not be deemed competent to stand trial either in the adult system or in the juvenile system because they cannot even grasp basic legal concepts. I don't know how many of you have raised children or have had a kindergartner or 1st grader ask them what they know about their Miranda rights or what they know about basic legal processes. And this is why this legislation is so important, because it recognizes that children who are very young should not be adjudicated delinquent because they're not criminally responsible for their actions. Between 2019 and 2021, there were 117 juvenile complaints that were filed in Virginia alleging delinquency. There was only 1 finding of actual guilt, 9 dispositions of probation, and 0 commitments. So I think that there is this basic recognition on the part of judges that we should not be committing children this young to our systems, and we should not be adjudicating them delinquent. But it's important to make sure that the statutes themselves are consistent throughout the code. This is also why I'll note just real quickly that conservative organizations like the American Legislative Exchange Council have actually encouraged the passage of legislation citing conservative states and the conservative leadership of states such as Texas, Louisiana, Arkansas, Mississippi, Utah, and Nebraska, which have all passed similar legislation. And the last thing I'll note on this, Mr. Chairman, if I may, is that when we're talking about this group of young children who come into the system, we're oftentimes talking about the most vulnerable and disadvantaged children in our system. Studies have shown that Roughly 90% of all children involved in the juvenile justice system have been exposed to adverse childhood experiences and early childhood trauma, everything from physical and sexual violence to being a victim of neglect to having a parent who is incarcerated. Children, about 50% of those children have 4 or more of these adverse childhood experiences. So when we're talking about this subset of kids, it's also important to understand that they're the most vulnerable children in our society. Again, kindergartners, first graders, and second graders. This is also key to disrupting the school-to-prison pipeline and the sex abuse to prison pipeline that some folks might not have heard of. But it's specifically acute with girls, where we find that girls who are system involved, 73% of them were previously sexually abused before they came into the system. And so with that, Mr. Chairman, we would encourage this committee's favorable support because establishing a minimum age for juvenile delinquency in Virginia is a human rights issue, and it's important to recognize that these children should not be held criminally culpable. Thank you so much.
All right, thank you. Anyone else in the audience? All right, I believe there are a few people online, as mentioned by the patron. We have Valerie Slater.
Mr. Chair, members of the committee, thank you so much for your time. And yes, I am representing Rise for Youth and the NAACP of Virginia. And nowhere is such bipartisan collaboration more needed than when we are talking about how we're going to treat our children in the justice system. We've got to be able to agree, first of all, that children are different from adults, and we've got to treat them differently. And so as we are looking at, even when kids commit harm, we are not going to minimize that harm, and we're absolutely going to hold children accountable, but how we do so is really important. It's a Supreme Court that has repeatedly said that age is more than just a chronological fact. And so we cannot throw our young people at the mercy of the full justice system. We've got to treat our children, and especially those that are younger than 11 years old, we've got to treat them through other means. We have both the Child in Need of Services and the Child in Need of Supervision statutes that are there and able to support our children that young. It's already been stated, but children's brains, they're not fully developed. So we can't simply treat them as if they are miniature adults. And no matter what they've done, we still have got to realize that we are talking about our youngest and most vulnerable children. So we've got to allow our youngest children to be placed in, we can't allow them to be placed in correctional facilities, but rather making sure that they are indeed treated as children that need care. Thank you so much. And so please support this bill.
Thank you. Elizabeth Barnett.
Hi, this is my video. Greetings, committee members. I'm a pediatrician and researcher at UCLA. I provide clinical care at Juvenile Hall, and I'm speaking on behalf of myself and Professor Dr. Laura Abrams. So I want to start by telling you about a year ago in New York, police were arrested a 9-year-old girl for a mental health crisis from a family call. And one of the police officers, as he was arresting her and pepper spraying her, said, "You're acting like a child." And she said, "I am a child." The problem is that we're forgetting to treat children like children. And in doing so, we're losing sight of childhood. California successfully passed a minimum age law of 12 in 2018, and the bill has been implemented successfully. Before the legislation, California was also prosecuting kindergartners, 6-year-olds, 8-year-olds. 6 child health professional societies, including the American Academy of Pediatrics, recently endorsed a statement calling for a minimum age of at least 12. And they stated, quote, "Children need access to developmentally appropriate, trauma-informed, supportive health and social services, not inappropriate punishment." And the rationale that they have given is, as we're hearing, children's brains are developing, children have a normal immaturity and are unlikely to benefit from or understand processing in the legal system. I have a 7-year-old boy, he still sleeps with stuffed animals. There's a pipeline of recidivism and a sequela of adverse health effects that can begin very young when we put children in the justice system. It's much better to address the root causes of children's distress. Furthermore, restitution, holding kids accountable for their actions, can happen much better outside of a court. And there's a very important issue of racial injustice. Our research has shown that the youngest children are even more disproportionately of color than the older children in the justice system. Therefore, I urge you to support House Bill 1248. Thank you so much.
All right, thank you. Julie McConnell.
Good afternoon, Mr. Chairman and members of the committee. My name is Julia McConnell. I'm an attorney and also a law professor at the University of Richmond. I run a clinic called Children's Defense Clinic. So I've been representing kids in one form or another for about 25 years. And I just wanted to speak to the fact that there may be some concern that we would not be able to address whatever is happening in a young person's life if we put the age at below 11 for prosecution. But I want to clarify that you can always use the CHINS process to address whatever might be happening. If a child is engaging in delinquent behavior at 7, 8, 9, 10 years old, there's most likely an issue there that could be addressed through the CHINS process. Services can be put in place to help the family, help the child, and that makes a lot more sense than prosecuting them for a delinquency, which never gets to the root cause of the behavior. I've served as a prosecutor in juvenile court as well as a defense attorney. I've actually had to represent 8 and 9-year-old children charged with offenses, and they were never found competent to stand trial. So when we charge these young people, we waste precious money and resources and time trying to get them to the point that they can be competent to stand trial, and it rarely ever occurs because they just don't understand what's happening in court any more than they were able to form criminal intent to commit the delinquency. And so I'm asking you to consider this to be an appropriate line to draw in the sand, because there are ways that we can address this behavior. We don't need the delinquency court system to do that. And you may know that the Department of Juvenile Justice provided statistics that show that these cases actually make up less than 0.4% of all juvenile intakes from fiscal year 19 to 21. So we're talking about a very small number of kids. And the vast majority, I believe it's 61%, were misdemeanors. So we're talking about, in many cases, very minor offenses. And again, anything the court would do on a delinquency case, except incarceration, they could do through a CHINS, because it's really services that are needed as opposed to punishment. I'll also say that it is extremely expensive to try to get children to the point where they can be tried when they're that young, and we could be using those resources to put in place evidence-based, trauma-informed responses that will actually, hopefully, divert those children away completely from the juvenile justice system. And what we've seen is that when we do divert children away from court, that the recidivism rate is extremely low. That's where we have our greatest successes. And so to say very clearly that we won't be taking any child under 11 to juvenile court, but instead handling it through a more civil process that will be service-oriented, really makes a lot of public policy sense. And there are 19 other states in the country that have done something very similar in setting a floor. It also is very much in line with legislation you passed last year to say that we couldn't incarcerate children under 11. So it makes sense to also say we couldn't prosecute, because the only services, the only really dispositional option for the court for children under 11 that we can't do through a CHINS is incarceration. And you've already said that we can't do that for any children under 11. So with that, thank you. And I encourage you to support the bill.
Jennifer Newman.
Good afternoon, Mr. Chair. My name is Jennifer Newman. I am from the Office of the Executive Secretary. The court does not take any position on this bill specifically or on the policy behind it. The court's only concern is that given the way the bill is written, it would seem to completely redefine the definition of a delinquent child, which should impact whether or not a delinquency petition could even be filed. And if that's the case, then the dispositional statute that is added at the bottom of the bill on lines 360 to 363 would never be called into question to be implemented. that statute, that dispositional statute requires that the court be looking to see if the child is a delinquent or committed a delinquent offense. And it is our understanding that this bill is essentially initially creating a mechanism in which a delinquency petition would not even be filed or processed against a child under the age of 11. And we just wanted to bring that to the committee's attention.
You.
So, Mr. Chairman, addressing the Office of the Executive Secretary, I don't believe that I have been aware of that concern, and I'm not sure. Certainly, the intent of the bill, again, is that the child does not enter into the criminal justice system. And if in fact, the way that is read and counsel agrees, I certainly have no problem with acceding to the Office of the Secretary's concerns. While I'm speaking about the bill itself, the concern of VACA was that they wanted to be sure that they could go after someone for contributing to the delinquency of a minor who used a child of age 8, 9, 10 to commit their criminal activity. And so that is why you see on the original bill, it was line 73, where we have added the language to make it clear that a child under age 11 years old has committed a delinquent act, as well as inserting the code section 18.2371 so that we make sure that, again, you can go after the adult contributing to the delinquency of a minor.
Okay, thank you. All right, well, before we talk about possibly amending to address the Office of the Executive Secretary's concern, Counsel, can you advise the committee what is the status of the common law as respecting presumptions of crime, criminal activity by children?
Mr. Chair, the common law, and this really isn't anywhere in our case law, but it comes from the old common law from England, and it is that if you are less than 7, you are irrebuttably presumed incapable of forming criminal intent. From 7 to 14, you're presumptively incapable but rebuttable, and then 14 plus, you are presumed to be capable of forming the criminal intent.
And so the code sections that we have that allow for prosecution of juveniles as an adult are consistent with that longstanding common law principle, correct?
I would say that we, in our dispositional code sections, Virginia has actually brought it down to sort of 11 as not 14, but 11 being kind of the line where you go to that presumptively capable because of the dispositional statutes. But we are well in line with the common law.
All right. And I guess the issue I have, Delegate Watts, with the bill is the compelling need to do this. I think even the testimony from one of the proponents was that there was one case that we've had in Virginia where a delinquent had a finding against him under the age of 11, that there were, and then there was only a handful of others that were even charged with an act of delinquency. Is that correct?
And as I recall, it was less than 0.5% that were even charged, and it is that cohort that is the concern, because there is no reason to put these children into that situation with all the ramifications that would result from that versus funneling them directly into our juvenile services that are there to help children who are truly in need of services, and that is why there is that concern. So while the statistic of how few are involved was there to say we're not turning our justice system on its head. We're not opening the doors by doing this, but what we are doing is saying there are individual children who are not being directed into our social services and juvenile court services, et cetera, that need that rather than ending up with in a criminal charge situation.
Okay. Any other questions from members of the committee? Questions for counsel or the patron?
No.
All right, hearing none, the chairman will entertain any motions.
Second.
All right, there's a motion to report and a second.
All right, Mr. Chair, I move to
Delegate Bell?
have a substitute motion. Move to table the bill.
All right. All right, there's a motion to table that has been seconded. That's a superior motion, non-debatable, and is to be recorded.
Vivian has another bill sheet, rather.
Yeah, we've already passed that. I think it's
No, Vivian's bill we passed by, or did our hearing?
All right, please close the roll. The bill is tabled on a vote of 4-3. Okay, and I believe